Now, we advertised ourselves as this really innovative seminar, Fishbowl. And we spent a lot of energy, and we were very excited about doing a fishbowl for you today. And then when we got here, we realized and were told that we're not allowed to move the tables or the chairs, so you're going to get a faux fishbowl. We apologize. So you won't have semicircles around our speakers because you all are locked into this lecture format. So we're going to try to be as casual as possible. We're going to try to follow the fishbowl format, which is our two speakers will be having a conversation with each other. I'll be posturing some questions to them, and we hope that you will posture questions as well. And the way you can do that is either by text or Twitter. And the questions should appear on the screen, so if you want to practice, go ahead. And then our speakers will look up at the screen periodically and hopefully be able to answer your questions. So with that, we're going to get started. We apologize. Imagine yourself in a fishbowl in this very innovative, non-lecture style training, and we'll do our best to make it feel less formal than the setup of the room. So without further ado, I'm going to turn the mic over to Jessica.
Are we going to move our seats there in the middle?
Come over here.
See us?
Come over here
Okay.
with your chairs. And imagine yourself surrounding them in a semicircle. If you can't hear or see and it's annoying that they're sitting down there, there's no reason why we can't do this standing up. So just let us know. You can actually send an anonymous message to this. Hey guys, I think you really should be standing. I can't see you. And we won't know who said it, and we'll go ahead and act upon your suggestion.
Actually, we'll know who said it, and we'll come get you afterwards. Good afternoon, everyone. Thank you very much for being here today. My name is Jessica Ray. I'm an attorney with the Community Law Program, which is a legal services provider in St. Pete, Florida. I work with kids that are aging out of foster care. My clients range in age from about 13 till about 25 or 26. Although recently I've had two outliers who are under the age of 3. So it's been a very interesting ride. I became involved or thought more about the ADA when I picked up one of the cases of a young person who was in a nursing home. And that sort of got my fires going about thinking more creatively about what tools I have in my advocacy toolkit box to argue on behalf of my clients. Thanks again for being here.
Hi, I'm Matt Beeks. I'm Litigation Director of Disability Independence Group. I've been handling disability rights cases since about 1996. I've handled about 300 to 400 different matters in the disability rights law, anything you can imagine, from public accommodations to education to testing accommodations to Fair Housing Act to service animals to everything else that's there and available. If you touch something on that, it will wake up. Okay. So, and basically when it comes to the ADA, the issue is essentially how to create a level playing field. And in doing so, the question is what services and programs is everybody getting? And children with disabilities or persons with disabilities should have the same access to the same programs. Or on the other hand, what accommodations does the person need in order to get access to those programs? So basically, what you do is when a child's in a position and not getting something that everybody else is, you ask why. And that's the first question you always ask. Why is this child not in a class with other children? Why is this child not getting services? The other important thing is whether or not a child is in the least restrictive environment. What is actually happening, and how can you make that child get in the least restrictive environment, or what services can you do, notwithstanding any disability that that child has? So, you want to start out with?
Yeah. How about, we'll start with, what is the definition now? We'll start with you. What is the definition of a disability?
Okay.
We'll start at the bottom and work up.
So what is the definition of a disability? This is one of the most debated questions in the entire ADA. And actually, the law was changed in 2008 because courts were getting it wrong. Well, in my opinion, courts were getting it wrong because I always represent the person with a disability. You either were too disabled or you didn't have a disability, but you were never a person who was a qualified person with a disability. But a disability is a substantial impairment of an everyday life activity. Sleeping, breathing, learning, concentrating, walking, breathing, or it could be a substantial impairment of a major bodily system, such as cancer, diabetes, epilepsy. It could be sporadic. For example, if somebody has a seizure once or twice a day and then doesn't go for a week and then has a seizure. Or it could be something that's constant. It could be something that is not currently active, such as cancer. A person who has active cancer is of course considered a person with a disability. A person whose cancer is in remission is also considered a person that has a disability. So that essentially is what a disability is. And when it comes to children, the most frequent thing that we see are children that have a learning disability. In fact, in schools and colleges, about 90% of all accommodations deal with extra time on tasks. And that is an issue that's a very hot topic. In fact, yesterday, the Department of Justice entered into a settlement with the law school admission tests regarding what exactly can a testing organization ask for when a child has a disability in order to give them an accommodation. Because what would happen is every time a child would apply for a different test, they would get evaluated again. And every testing organization would have its own evaluation of what that child needs. So what actually happened is the Department of Justice said, basically entered into an agreement with the law school admission counselor, which is one of the worst in my opinion, and said a person doesn't have to be evaluated only once every 5 years. That if a person receives any testing accommodations, post-secondary, from the SAT further, that testing accommodations will continue for whatever test that you have thereafter. For example, if a child got double time on the SAT, that same child would be entitled to double time on the MCAT or the LSAT or the GRE without having another evaluation, without going through all of the rigmarole. But it's a great settlement, and that happened yesterday. So whenever you're talking about the ADA, you're talking about something that's constantly evaluating, and it's much more difficult with hidden disabilities rather than physical disabilities.
And Jessica wanted to talk about the PowerPoint, so you want to...
Sure.
Because we brought you some slides. Jessica wants to go to the PowerPoint.
What I wanted to raise is very important to think about when you're considering whether your client is entitled to protections from the ADA, is that determination of whether your client fits somewhere on some magic list of definitions. I'm a lawyer, so sometimes I really look for something in black and white. So, I want someone to give me a list. Does my client fall on this list? And if yes, then I can check the box yes, and if no, then I can go to the next tool, right? Anyone else like that? Right, okay. Sorry, no such list. What I like about the ADA is something that I think we should be practicing in every single child welfare dependency case, is it's an individualized assessment of what is going on with that individual client. So what I think is very important to remember is it's not one size fits all. There are certain categories that would automatically fall under the ADA, but you're not limited to that list. So I don't want folks to leave this conference and start going to look for a list of if their client falls under that. What I think is important to think about as a strategy, what I was thinking about is, do I think that my client is disabled? Do I think that there's a disability? If I think it is, what is that disability? How does that disability impact my client's ability to participate in whatever it is that my client wants to participate in? Is it that my client wants to go to daycare with a sibling, but my client has some sort of developmental delay that makes him not be potty trained, and that daycare doesn't do diapering for children over 3 years old? Is that something that's preventing my client from going to enjoy the same daycare that the siblings have all enjoyed? Is it that my client has trouble reading because of a learning disability, and then he's being handed a case plan? Who in this room has seen a dependency case plan? Who in this room is able to read a dependency case plan? You're all lying, right? Okay, so that's exactly right. So I think we've got to think about individual assessments of whatever disability our client may have, how it impacts their ability to engage in whatever process they're involved in. And so I think, I just wanted to bring that up. It's not a very technical suggestion, but it's just a common sense. If something doesn't feel right, if it feels a little hinky, it probably is. And I'd ask you just to push down and dig a little deeper on that issue. Does that make sense? Okay, turn it back over to the expert.
Do you want to work on go through your slides?
Well, if anybody has a question on these slides, raise your hand. Reasonable accommodations. One of the things that I see often is dogs love the issue of dogs. Thinks dogs are a growing issue. And here's a picture of Stevie, the dog, and his owner, Anthony. Anthony had a CP. He goes to Broward schools, and he wanted a service dog. And we're in litigation now because the question is, who controls the dog during the school day? When is it a reasonable accommodation? When is it not a reasonable accommodation? Is it a reasonable accommodation for the school district to hire a handler for the dog? Is it not a reasonable accommodation? So these are all the questions that come up. But on most circumstances, when a person can control a dog, they could have a dog. It's really the essence of the ADA is personal independence. How can we encourage people to be independent for themselves, whether or not it's independent on a daily basis with regards to the choices that they make, or whether or not it's independence with regards to choose what type of medical treatment that person wishes. Anthony's mom thought a Caesar alert dog is the mode of treatment that she saw. And it's important as a guardian to facilitate what a person with a disability's own choices, because independence and self-advocacy is something that is essential. But there are other issues for service animals, and not only are service animals protected by the ADA, they're also protected by Florida Statute 413.08. 413.08 allows a person to have a service dog, or it allows a service dog in training for physical disabilities, or other disabilities, or epilepsy dogs, or other disabilities such as that. The Florida statute does not permit emotional support animals. Emotional support animals are a huge issue now. Emotional support animals are to assist a person with anxiety or depression or agoraphobia or anything in which an animal is not individually trained for that specific person's disability. The definition of a service animal is a dog or a miniature horse that's specifically trained to assist somebody with their disability. An emotional support animal can be any animal. It could be a cat. It could be a ferret. It could be a hamster. It could be a parrot. It could be a snake. just as long as it assists a person coping with their own disability. And a lot of the cases that are coming up now with the Fair Housing Act deal with emotional support animals. But there's no right to having an emotional support animal in a public facility or in a school. Now, when we talk about disabilities, there's some disabilities that animals really help. For example, autism really helps a child with autism to open up if they have a dog. And it can be part of the treatment. Helps with epilepsy. Helps with anything that involves socialization. An animal is perfect. Also to help a person pick things up if they have a physical disability that they cannot pick things up. And of course, guide dogs and hearing dogs. But there are also other accommodations as well that you would have to look at each one to say, and a dog's no different from any other accommodation. What is reasonable? Is it a reasonable accommodation? Does it help the person with the disability? Does it lessen the effects of their disability? Then they should be allowed to have the dog. Or animal.
So my question to you is, I have a client that has a variety of medical issues, including diabetes. She thinks and would like a service animal to work with her. She thinks that would be very helpful. How does she go about getting that?
Now, it depends. Is it housing? Is it employment? Is it public accommodations? If there is no licenses or certifications, official licenses or certifications for service animals. A service animal can be self-trained. A service animal can be trained by a professional agency. The service animal, the only thing the law requires a service animal to be is to be individually trained to assist a person with a disability. And when a service animal goes into a public accommodation, they can only ask, is that your service animal? How does the animal help you? They can't ask anything else. They can't ask about the nature or extent of disability. But there is no official training. If you want an animal at a person's home, they may ask a letter from a doctor if the animal is an emotional support animal and the disability is not obvious. And the letter from the doctor pretty much has to say the animal is part of the treatment for this person or this child. The child has a disability or the adult has a disability, and the animal helps this person or child with their disability. Again, the condominium association cannot ask detailed questions about a person's disability or the nature and extent. And it's also the same thing as for the employment or school-based issue as well. But with an employment issue, you really have to look at how the animal helps. Is that animal going to be a fundamental alteration or an undue burden? So those are all questions. A fundamental alteration means, does it in some way substantially affect the organization's business, how the organization does things? Is the organization going to continue to do things if that animal is there?
Let's see if we have some questions.
What is the mechanism for getting a service dog for a child in foster care? Who pays for it? Well, service dogs are expensive, and there are many organizations that actually give away their service dogs. Not give away. They train their service dogs. You have to apply to be a partner with a service dog. You have to spend 2 weeks and become a pair with that service animal. And there's several organizations that do that in Florida, but it's an application process. And they view whether or not it is a good fit between the service animal and the person. There is no other official way that service animals are paid for, to my knowledge. Do you know any different?
I think the basic answer is that this is a service that the client needs or the child needs in order to engage in regular activities or to make their life completely whole. And we'll get a little bit further down to specific case planning ideas. I I think the first request is to go back to your community-based agency and say, this is a service that has been recommended for this child. How do we go about doing that? And then we go to the famous beg, borrow, and steal, right? So you ask someone for a donation. You ask someone to fund that dog. You ask the agency to pay for it. You ask for some combination of that. I think it gets overwhelming sometimes is we kind of get stuck at that first step. Someone has recommended that my client would benefit from a service dog, and then we kind of get stuck. I don't know how to do that, right? So I think the first thing we figure out is where do we get the dog from? We look up one of the nonprofit agencies and say, how do we get a dog? This is how it works. What are the expenses related to that dog? Then the second question is, well, if we do have expenses, how do we fund them? Sometimes when we have kids that are involved in the foster care system, they get Social Security benefits. And there is a possibility that that would be a completely appropriate use of a fee waiver, right? Anyone heard of fee waivers? Okay, so what that is generally is if a young person is receiving their Social Security, let's say SSI monies, the state is taking that, they're putting that into an account, they're reimbursing themselves for the cost of care, with the exception of $30, which remains in the account. That child has the right to ask the state, wait a second, don't take that money to reimburse yourself for care. I have a special need, and in this case, my special need is I need a service dog. I would be horrified and actually very shocked if DCF denied that request. If the child for some reason doesn't receive disability benefits, which might be the case, there are two follow-up questions that I would ask. One, should they be receiving SSI benefits? And if they aren't, let's go ahead and apply for those. And then the second would be, let's go back to the community-based agency and ask for funding to cover the cost of that animal. Then I think you also have to think creatively about how that funding continues on, because what we don't want is a young person to get supports and services. Until recently, remember, we were brilliant. We thought that every 18-year-old walked out of foster care ready to go. We have reassessed that judgment and realized that that's probably not true. We want to make sure that that transition, whatever the services are in place, appropriately transition with the young person and don't come to a stop at 18. So those are the two things, practical things that I think that relate to kids in foster care.
I just want to make one comment.
I think it's really important for all of you to think about this. In my 30 years in the system, I've never had anybody discuss how important the relationship between an animal and particularly the children that we serve might be. And so I challenge you all to really think about it. The easy thing is to go, oh, that's the last thing I need to worry about on top of everything else. But the challenge is, what a meaningful difference. The trauma and all the kinds of things that our children go through, what a meaningful difference this element might bring to the picture. So I challenge you not to just think of it being too hard. Yeah, it is hard. It would be hard. But it might be a whole new element that we can bring into the service piece and the safety net that we are tasked with providing. So hopefully you'll be calling these folks with questions, because they'll help you make this happen.
I'm going to transfer it a little bit to something that's been taking a lot of my time over the past 2 years. Medically complex children, medically fragile children. These are our most fragile children that we deal with. Most fragile children that any guardian ad litem would deal with, or any guardian would deal with. These are children that, medically complex children are children that rely on 24-hour per day medical care or supervision. Medically fragile children are those complex children that need mechanical supports, such as one of my favorite little kids here that uses a ventilator. DCF, about a year ago, DCF promulgated a policy in which they said that it is in the best interest of all children to be in in the least restrictive environment and family-based environment as much as possible. There are currently, I believe, 13 children that remain in nursing homes today. There used to be 30. And these children are the kids that are victims of shaken baby syndrome, victims of meningitis, kids, all those TV things that you hear where a kid a toddler wanders into a pool and has near drowning. Those are also genetic issues as well. But when it comes to an accident, it's mostly shaken baby syndrome, automobile accidents, or near drowning. And one of the questions that you have whenever you have one of these children is, what's in the best interest of these children? Are these children verbal or nonverbal? What do you do? These are all wonderful children, and I've seen many of them. So, what is the best interest for these kids?
So I have the privilege of representing 2 young folks who are currently in nursing homes. I have one young person who is very verbal and one who is not. As the attorney for the child who's verbal, I obviously have the pleasure of representing his announced desire. And what I have learned from him is that it's really hard to live in an institution. It's really hard not to be around other kids. It's really hard not to have the opportunities to go to school, to enjoy activities that are outside a facility. My other little guy is nonverbal, but let me tell you, when you walk in the room and he recognizes you, he lights up. When you talk to him or you point things out, his eyes follow you. And what I find is we always talk about wanting the best for all of our kids. These kids deserve nothing less than that. And so I think our obligation to these kids is exactly the same to every other client that we have. We do our very best job to get them the best services possible in the least restrictive manner that is available to meet their needs. So that means that if they need to be in a nursing home level of care because that's the level of care that they need, then we want to make sure that they get that level of care, that they are well cared for in that facility, and in the moment that they are ready to be stepped down to a more family-like community setting, that we hunt for that. Now, we do know that in Florida there are some challenges around that because there are not enough medical foster homes or medical foster homes that are available to take some of our kids, and we also know that we are struggling finding nursing for the kids that require nursing. What I've been doing on cases is having conversations with the agencies to develop alternative methods of meeting those child's needs. If the rules require that nursing be provided through one type of agency, asking them to allow us to get it through another type of agency where there's availability to provide those nursing hours. I think these cases for me are the most challenging because we always talk about least restrictive in the dependency system, right? Least restrictive is we remove the child from the home. Well, first of all, let me back up. Least restrictive is we don't remove the child from the home if we can keep the child in the home with safe services and maintain that family. If we have to remove the child from the home, then we place them somewhere close to the home so that visits can continue, that they can remain in the same school, that they can see their same doctor, that they can see their friends. If we can't do that, we want to place them with family so that they're with family. If we can't do that, then we want to place them in another similar situation, which is most like their family setting. And if we can't do that, then we step down the line. How many folks have seen kids that have been removed and immediately placed in a group home that's 4 hours away from their home? Yeah, it happens particularly, like I said in the beginning, I work with teens. I would say that happens 75%, maybe even higher than that in most of my cases, because we just simply don't have the least restrictive environment. It is critical for young folks' well-being that they be in the least restrictive environment so that they're able to participate in the regular activities. I think tonight and tomorrow we're going to hear a little bit about Olmsted. Are folks familiar with that decision? Okay, so I'm seeing nodding in the room. Where's my little notes? There's a quote from that decision when the Supreme Court was deciding it. And this is when the court found that unjustified institutionalization formed the basis of discrimination for 2 such reasons. One is that institutional placement perpetuates unwarranted assumptions that persons so isolated are incapable or unworthy of participating in community life. And the second is confinement in such an institution severely diminishes the everyday life activities of the individuals, including family relations, social contacts, work options, economic independence, educational advancement, and cultural enrichment. Whenever we don't place the child in the least restrictive environment, I encourage you to change that from an institutional setting, change that to repeated Baker Acts, to a group home 4 hours from their parents, to a SIP placement, to repeated SIP placements. I think what's really important that least restrictive is not just a term of art that we pay lip service to when we're working with kids in dependency, but that we really make it the driving factor about how we serve the kids and their families. So again, my little practical tip.
And I think one of the major things is what are the tools? How do we unify a child that has medically fragile, medically complex with their family, because that is the ultimate goal. How do you get enough private duty nursing care? What do you do? How do you get the kids to service? How do you go into schools? These kids, a lot of these kids that are, there's about 3,000 children in the state of Florida that are medically complex or medically fragile. Most of them go to school. So they go on school buses, they go to school, they should get therapies and nursing when they go to school. The question is, what happens when they get home? In order for a lot of these parents that have medically complex, medically fragile kids are unsure of their own abilities. They don't know what they can do. And all of these kids are entitled to EPSDT services, which how many people know what they are? Okay. EPSDT services are a series of 28 different services that Medicaid pays for children as long as they're medically necessary, which medically necessary should be what a doctor says is medically necessary. But it's sometimes not always that. But in as much as it is, it's our job it's the guardian's job or the attorney's job to advocate to ensure that that child has the service that that child needs in order to be transitioned back home so their parents are comfortable with the care. If that involves 24/7 nursing care, ACA, CMS will pay for 24/7 nursing care. If that involves therapy, the school system should pay for the system devices for the kids to bring home through the IEPs. There are also special guardianships solely for not guardianships. It's sort of a guardianship program for kids in special ed to make sure that they're well represented in their IEPs. So it's important to ensure, in order to increase unification, to ensure that children get proper nursing care, proper therapies, and if they're not, what you do is you have to go to you have to go through EQ Health appeals hearings to ensure that the proper services are maintained, and you need your doctors to come in and say that these services are medically necessary. That a PPEC is a prescribed pediatric extended care center. Those are daycare centers essentially for medically fragile, medically complex kids. They're useful in a more integrated setting than being at home, but they're useful for kids that are between 2 and 6, and could go outside for some services and some socialization. I still don't understand why BPK isn't integrated, but that's a whole other issue. But there's all these services, and it's important for reunification to ensure that all of these services are in place. Yeah, one of the next issue. Another very hot issue in dealing with children with disabilities and adults with disabilities is something called supportive decision making. Supportive decision making is what the role of a guardian is. The role of a guardian is not to substitute their decisions or their choices for that of a person with a disability. It is to facilitate the judgment that the individual would make if he or she were able to express that judgment, rather than say the best interest or what the guardian thinks would be right for the guardian. This summer there was a case, Jenny Hatch, up in Virginia. Is anybody familiar with it? It was a fascinating case about a 29-year-old girl with Down syndrome named Jenny Hatch, a young lady with Down. And Jenny Hatch wanted to live not in a group home that required her to work where she didn't want to work, required her not, would force her not to see her friends, would put her in a sheltered workshop. She wanted to do things on her own. And she was able to make some of the decisions that anybody could make. As with any other person, people make bad decisions all the time. You don't have to have a disability in order to make a bad decision. And, right? And just like any other person, a person with a disability can make a bad decision. The question is, what decisions can the person with a disability make or not make? What are they able to do and what are they not able to do? I had a gentleman call me yesterday. He was from Colombia. He had a son who was autistic. His son is 18 years old, and he couldn't understand the citizenship test. So he had a psychologist test him, and the psychologist said he doesn't have the capability of understanding the citizenship test. So his sister signed for him and he became a citizen. Well, he wanted to get a passport the next month. And the State Department said, well, your sister had to sign the citizenship documents for you. You should get a guardian in order for you to get a passport. And I went to the dad and I said, your son can make some decisions on himself. Do you really want to take away all of your son's decision-making capabilities because he doesn't have the capacity to answer the questions on a citizenship test? So we have an issue where we decide that a guardian should take all the rights and powers away from a person or a child and make a decision that they think is right. And now the trend is going to how much of that decision-making can be left with the person. How is this important? When you're dealing with a younger child, you have to see what decisions can they make. How can they lead their own lives? What can they do with their own lives? One of the tenets of the disability rights movement is nothing about us without us, which basically means that the person with a disability has rights to be independent, has rights to make their own choices, has rights to choose what is good, what course of treatment that they want for their own bodies. And the same thing that when you're a guardian for a person, you have to analyze what would that person want to do? Where would that person want to live? What job would that person want rather than to be in a sheltered workshop? Or to be in a home, not with their friends? Or not to be in school, or to be in a certain school, or to be in a certain class? Like any children with disabilities like making decisions, and it helps them to grow. Even the little girl who I was talking to in that last picture, the little girl has a trait. She can't speak. She's nonverbal. She's in bed most of the time, but she nods. She communicates. She knows what's there. And I would imagine that any decision that she makes is worth a lot more than the same decision that I would make, because it's something that is a focus of the limited independence that she has, and that's something, as a guardian, it's important to nurture. So supportive decision-making now is one of these buzzwords in the disability rights movement. And it all goes into the ADA. And let's get back to the ADA, because we talked about a whole bunch of things, and how does that deal with the ADA? People living on their own and having independence, a person with a disability has the right to be in the most integrated environment possible. To be with other people who may not have a disability. When you have a child in a group home with other children with disabilities, it does not give them the same access. When you have a child in a pediatric extended care center that is not with children that do not have disabilities, they don't have the same access. That's why as a society, we decided that what we're going to do with our special ed is we're going to mainstream persons with disabilities as much as possible into the normal system. Animals, how does that deal with ADA issues? Because it's a person's right to have treatment. A person's right to have a choice in the treatment that they choose. So anything that we talk about in the ADA is a civil right. You have a right to be in this world like anybody else does. You have a right to have the same choices that everybody else does. And our job is to maximize those choices, to say, in order for you to be with your parents, you may need 24/7 care. Because it's always better to be in a family-based environment than it is to be in a hospital or a group home, and that's what we have to foster.
Okay, so let's go back to, I want to talk a little bit about the practical of what do you do. I think the first place that you start when you are looking at your cases, whether you're the child's attorney, the guardian ad litem, the guardian ad litem attorney, the hearing officer, parent's attorney, anyone on the case, is what does the person who has the alleged disability want for themselves? In this case, we're talking about kids, but I also think for my clients, particularly my clients that want to go home, if I'm worried that the parent has a disability, I think about the ADA as well to make sure that we've got appropriate case planning. So I wanted to start with really thinking about individual case planning. So the first thing is I find out what the child wants. What does the young person that has a disability want? What is their goal? Where do they want to go? And then the next thing I do is I pull out that very complicated case plan, right? The one that repeats itself over and over again. Okay? You pull that document out and you look down and say, well, what were the issues that led to this child being removed? What were the issues that are going to resolve that brought this case to dependency? But I'm also looking for what services have been offered to meet the child's needs, right? I have yet to see a comprehensive case plan that addresses the child's specific needs, right? You usually see if the child comes in and they allege to have had some behavioral issues or maybe drugs, that the child's going to submit to random UAs, the child's going to comply with home and house rules. I'm not really sure when I crossed over to delinquency court, right back over to dependency, what services are supposed to make that child okay. I have yet to see that in a case plan, so that's the first thing. Is there something that we can do to modify the case plan? But I think we should always look at the language that we hear a lot of in dependency. We all know each other, we play together well in the sandbox, and I think it's very important as an advocate to stop. Sometimes it's okay not to get along with opposing counsel or the other parties. Sometimes you need to put your proponent, you always need to put your client's interests first, or the child's interests first, if that's the position, the person that you're representing. So the first thing is, if someone says, well, we're going to go with this provider because we always use the provider, right? Who hears that? Like, there are 4 providers that we use, and those are the 4 that you get to choose from. Well, if they're not able to meet your client's needs because they don't have the appropriate accommodations, they don't have a specific type of service that your client needs, then you can't use that provider. I don't care if they've always used it. I don't care if they used it back when the wheel was invented. I just don't care. Find something else. Well, it's too expensive. I don't care. Find something else. Right? Then we go back to the big bar and steel and looking at master trust and all those other things, right? Okay, and then the second thing is, why are we recommending this one service? Because you know those case plans, what are the parents' tasks? Everyone say them with me. Stable housing and income, cooperate with the case manager, do some random drug treatment, and if you treat positive, then we're going to do random UAs, right? We've got the same case plan tasks for every single case. Well, stop it. We've got to stop it, right? Because that's not an individual case plan. So again, the statute's really clear. The case plan tasks are supposed to resolve the issues that led to the child coming into care. So if the case plan has a wealth of really common tasks, well then that's a questionable case plan, right? It may work, it may be appropriate, but you wouldn't know that unless you take a hard look at the case plan. And then the other thing of these are the tasks that we require. One of my favorite clients who has severe learning disabilities and has a very concrete IEP about how he participates in group lessons and how things are supposed to be broken down for him, chunked into pieces. Well, we went to court and the issue was my client wasn't compliant because he didn't like to go to the IL classes. And so I said, great. So I called the IL person, I said, great, can you tell me how you're chunking the material? And they were like, huh? Right? Well, if that's how he learns, because he had a disability that required that material to be useful for him, was that it needed to be chunked, that he had to have additional time, that it had to be broken down, that it had to be repeated, well then why is he not in compliance? Why isn't the agency not in compliance, right? So I would encourage folks to make sure that you have all the documentation. If there's a doctor that recommends a specific type of service or benefit or support for your client, make sure that that is known in the school setting, in the home setting for my poor teenagers, in the group home setting, in their family setting so that they can be successful across the whole thing. What I find stunning is sometimes we don't know what other service providers have said works best for our client. So I think those are some fundamental steps. So now I've got the case plan, right? I've done my review. I know what my client wants. I've looked at the tasks. I've gone to court. I have been very successful, Judge Todd, in getting you to approve my case plan amendments. And now I have a case plan that says what I want for my client. And suddenly I can't get it offered to my client. I can't get those services implemented. What do I do when I think that my client's rights under ADA have been violated? And then what I actually do is I call Matt and he'll explain to you what you do. How do you file your ADA complaint? What would you do if you thought your client's rights were being violated under ADA? I usually call and say ADA is my first thing, and usually that panics folks. But if that doesn't work, I call Matt.
Okay. Yes, I get called all the time. And most of the time there's an issue and it can be talked through about what is right, what is wrong, how to do things. When it's an ADA issue involving the services, what you basically look at is there an homestead issue? To determine if there's an homestead issue, what you say is the person in a least restricted environment, how much is being paid, where in a more restricted environment compared to a least restricted environment. For example, the state of Florida has acknowledged that nursing homes are, having a child in a nursing home is 20% more expensive than having a child in the community. So in all circumstances where a child can be in the community, it's much cheaper to have a child in the community than in a nursing home, even with care. So if that's the issue, that's what you have to look at. When it comes to a kid who is not receiving a specific service and is stuck in a nursing home, you have to say what services are out there, what waivers are out there. Is a child eligible for a waiver, and is that child going to be homeless? I had a child who was in a nursing home and they were closing the nursing home, and the child was going to be homeless. If a child is homeless, you get on the expedited plan to get a waiver. So homelessness is always a trigger. And that helps. Not really an ADA issue. The other issues, the basic ADA issues, are something a little bit different. For example, a child needs an accommodation to go to a summer camp, and a child cannot get that accommodation to go to a summer camp. For example, this past summer, for some reason, I had many autistic kids who came to me who could not go to summer camps because in order to go to a summer camp, they were told they can't go, or they have to provide their own one-on-one aid to go to a summer camp, even if it's a municipal summer camp that can afford it. Now, a one-on-one aid is a service that costs maybe $10, $11 an hour, especially in the summer when most one-on-one aides that work for the school system are out for the summer. So it's not difficult to find a one-on-one aide, and a lot of times sometimes don't. So what do we do? That's an ADA case. Why is it an ADA case? Because you've requested a reasonable accommodation for the child. My child has autism. He needs a one-on-one aide. They denied the accommodation. We're not going to pay for it. It's not an undue burden or fundamental alteration. $10 an hour would not shut the place down. So there you have an ADA case. That is the easiest type of case. You have a service animal. They won't allow you to go someplace with a service animal. They say you can't go. Just had a caller that called me yesterday. Guy, a veteran has PTSD, goes to the shop, and they say, you know, we give everybody a loaner, but we're not going to give you a Mercedes loaner because we don't want your dog in the car. That's an ADA case. The ADA does not provide for damages against private entities. It only provides for damages against public entities when there is some deliberateness involved. When they know what the law is and they deliberately violate the law. And then you can sue a public entity under the ADA for damages. But most of the time it's not for damages. It's to get what you need. For attorneys, what that allows you is to get your attorney's fees as well. The ADA is a civil rights statute, like all civil rights statutes, there's a fee shifting. So if you win, the attorneys are entitled to their fees, even though the litigant, usually in most cases, just has the entity to do what it promised to do. One of the most common things that I see now involves the deaf. Now, I have 2 cases going on in which hospitals have refused to provide deaf children with sign language interpreters. Deaf children do not get interpreters when it comes to doctor's appointments, and do not get interpreters when it comes to hospitals many times. So that would be a violation of the ADA, even though that communication is essential. And the deaf issue is, how many of you have ever had a deaf child? Okay. When you have a deaf child, most of the communication is by sign. The English ability for a deaf child is very low across the board. For a deaf person that graduates from high school, usually their English ability is between 3rd and 4th grade level. Their main language is ASL. When you have a child who is deaf, you'll have to look at the grade level for an adult, which is 3rd and 4th grade, and think about what the grade level would be for the child. And most schools do evaluate the English grade level for that child. So you may have a child that has a 1st grade English ability when that child is deaf and young. So anything you give that child in writing will not be effective. So you're going to need an interpreter, whether or not it's for your own communication with the child. And you may, on top of needing an interpreter, you may also need something called a CDI, which is a certified deaf interpreter. They break things down more for the child. And a problem that we have, especially with deaf children in the dependency system, is a lot of them only know what's called home signs. But this is a whole other thing when it comes to the deaf. These are signs in which their parents teach them at home and they make up. For example, it's time to eat. Are you going to brush your teeth? You know, just basic old Panama. And the problem is a lot of those people grow up not having any language ability. And they're called linguistically incompetent. No matter how smart they are, they cannot be tried, they cannot make decisions. They do not have enough socialization to be able to operate in society, and they usually do menial things, but they have no language ability. And their only knowledge is home signs. If you think about it, how many of the things do people get on a day-to-day basis involve what you watch on TV or what you read in the newspaper? People that have no English language ability do not have that same access as people who don't. So when you're dealing with a deaf child who's grown up by parents who neglect them, and they end up in a dependency system that have no language ability, you have a problem. They need to be given as much intensive services to get back up to par to be able to operate in society. Where do these people go? A lot of them get put in jail because of the issue that, in addition to language, they don't have the cultural competency. They don't understand things that would be common sense for us to know are not normal. For example, a lot of people who are linguistically incompetent have issues involving sexual crimes. They don't realize the social impact of those crimes. I had one client a couple of years ago who was 18 years old who was arrested for molesting his 6-year-old stepbrother. He was linguistically incompetent and the judge deemed him to be linguistically incompetent and ordered DCF to rehabilitate him. DCF sent him to Chattahoochee, where they gave him books in order to make him understand English, but of course if he can't read books, which again, he didn't understand English. So after 2 years, the judge said, I'm dismissing the case without prejudice. He's incompetent to be tried. After that, the Department of Health and Human Services entered into a settlement agreement with DCF, and they agreed to provide interpreters for all of their services. So if you see programs now, they were as a result of Eric Cole. So I thought I had the best case written. Plaintiff attorneys, 1983 case, falsely imprisoned, not done anything. The kid disappeared, had no idea what was happening. He became a migrant worker for about 4 years. He comes back, he gets arrested again in Polk County for trying to have sex with a Great Dane. Again, doesn't have the cultural competency. So deaf children are really a lot harder because you really have to fight to get to the basic level of understanding, whether or not it takes sending a child to National Deaf Academy in Mount Dora, which is a facility for the deaf, but that costs about $130,000, $140,000 a year. It's really expensive. So our system with the computer sort of went on with length with questions. So if there's any questions, please raise your hand, and I'll be more than happy to give you the mic. Yes.
Not a question as much as a suggestion. The question you have is if a child needs services under the ADA that you have identified, and it's a dependent child, and you're under a jurisdiction of the juvenile court, there is a case called Howlett versus Rhodes, a U.S. Supreme Court decision that says that the dependency court judge, the circuit judge in the state of Florida, or even a delinquency court judge in the state of Florida, has the capacity to act like a federal judge and to order a federal right. You don't have to sue for damages. You can ask the judge in the dependency court or the delinquency court for the specific relief you want.
What was the name of that case again?
Howlett versus Rhodes.
The citation?
I'll give it to you in 1 minute.
Can you spell Howard?
H-O-W-L-E-T-T.
So I just wanted the summary of what you do when your client doesn't have the services they need. One, you call the agency that's supposed to provide the services, say, I think you're violating my client's rights, or you are violating my client's rights under the ADA, please provide the services. So the first step is, one, ask nicely. Second step, when they say no, I would follow it up with a not so nice or more stringent letter. So the second tip is ask not so nicely. The third is then I threaten to take it to court or sue. The fourth is I call DOJ. They have their own section that will investigate those complaints. They will often make a phone call and offer to mediate the issue, to resolve the issue. And if that doesn't work, 5, I sue. Just a quick thing is you don't have to, this is not one of these processes where you have to exhaust the admin process first. You can go right to court if you need to. And so if you've got a client that is desperately waiting on services, I wouldn't, wait my whole process step. I would go right to court and say this is what is needed.
Can I just ask you earlier, I'm loud, I don't know if any
in non-compliance.
Well, my understanding is that in a case plan, we have services for children, not tasks.
Oh, yes, you're exactly right. The comment was that there was a comment about a child being in compliance with the case plan. If you look at the statutes, one of my pet peeves is there are case plan tasks for the adults and the agencies involved in the case plan. Again, look at your case plans really carefully. Find out what are the tasks of the case management agency. They should actually mirror the tasks or complement the tasks that are provided to the parent. Children should get services, not case plan tasks. So yes, I was outraged on many levels, but it was easier to be outraged on this one particular one because I knew that it was going to be a problem. Remember, the idea of the ADA is, and again, it always shocks me how much I learn from new clients. Every time I get a new case, I'm like, wow, I didn't know that before. And it's great to just keep adding tools to your advocacy kit. And I think that's what's so great about the ADA. It covers everyone. The definition of disability is very broad, and that's something, I mean, for those of us that are lawyers or those of us who are advocates, that's what we're supposed to do, right? Advocate, be creative, be zealous on behalf of the folks that we're working with. And so I think that's what's nice about the ADA. It is another tool that is very powerful when we've got kids that are caught in a system. And I had one last slide, but all I'm just going to say, the question was, how do you get, when do you start thinking about these issues? And the earlier, the better. Because if we have a young person that is not getting the appropriate services, that has a disability, and they begin to, jump in and out of Baker Acts, what we know about those cases, then they become harder to place, right? Because that file that begins to follow them then says, well, this is a child, you don't want to have this child in your home. And so then we send them to a group home, right? And then they can't get the services they need because they're in their group home, because then they're fighting with their roommates that are moving in and out of the group home, so then they lose that place, and then we can't send them to the other better group home because they've been in Baker Acts and now they've been in a couple group homes, we don't want them. And so then they get somewhere else, right? And then by the time we get to the point where we've got to fix it, we have done so much damage that we might as well have just left them at home in the first place. And I think that's what's so empowering about being a lawyer or an advocate for a child, is you get the ability to say, whoa, I'm going to stop the crazy train. We're going to figure out how to go forward for this young person. And the ADA is just some tool that I think, as advocates in the dependency system, we haven't even begun to tap into as a resource. And so I think this was somewhat, fishbowl experience. And I really want folks to think about using this as a tool and be creative. The worst that we can do is try. The best that we can do is change a child's life. So.
Another thing which I think is you always have to look at the resources that are around you. For example, if you have a child who is visually impaired, the National Federation for the Blind is great. They have a lot of different programs, a lot of different services. And there's many resources like that in the community and around. The Centers for Independent Living in the community always has resources, always has things that are available for children with disabilities and stuff that's out there. So no person is an island, and there's always things that are out there for folks. And some of the things that I see for parents are really troubling, especially when I get involved with these medically fragile children, such as kids that are not already on the wait list for APD for a waiver, missed devices, or in a brain and spinal cord injury program. So they have to be prepared to get what they need as soon as possible. And even if it's not a major disability, even if it's a minor disability like a learning disability, in order to get accommodations in the future, in order to get job accommodations, you really have to have the history of having a disability and also accommodations that are granted. So when a person goes to work, they know what's out there. Some of the things, one thing that I really wish that most of my clients did is have a book. What accommodations do you need? What accommodations did you get in the past? There's this resource, AskJAN.org, which is the Job Accommodation Network, and they have a listing of every single disability that you can think of, and all these job accommodations. Because hopefully, your ward will become employed. They have to know how to self-advocate for themselves. They have to know what accommodations are out there. They have to know what they need if they go to college, if they get a job. So you have to start as early as possible and know what that person needs and know what's out there for that person.
Can you say that website again, please?
AskJan.org. It's called the Job Accommodations Network. There's also other resources, ADA.gov. ADA.gov is everything you could possibly want on what compliance means in the ADA, including all the regulations, from what's required for the deaf and hard of hearing to what's required by police. Also a huge thing, what's required by daycare centers. The fact that daycare centers must test, must be willing to test children that have diabetes and cannot block kids with diabetes from going in their programs. So as much as we can talk about kids, medically fragile kids, we're also talking about kids with diabetes or kids with learning disabilities and kids with other disabilities that do not reach that medically fragile, medically complex state. Okay, if there are any other questions? If not, we're done. Are there any other questions?
Matt, tell everybody there's a sheet in the back with the contact information, so if you have a